Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. Today, ladies and gentlemen, we'll provide another installation to our Anti-Federalist Papers series going on number 46. So if you haven't gone back and watched 1 through 45, I would highly encourage you to do so, because understanding the Anti-Federalist Papers, in addition to the Federalist Papers, will provide you a very well-rounded, very advantageous understanding of the U.S. Constitution, and understanding the U.S. Constitution will be absolutely necessary if you intend to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So let's go ahead and jump on over to the Anti-Federalist Papers. There are multiple institutions from which you can get a paper and digital copy of the Anti-Federalist Papers. Go ahead and get both, just in case you can't access one or the other for whatever infinite number of reasons. While you're out there looking, if you haven't done so already, go ahead and get a copy of the Federalist Papers so you can join us in contrasting and comparing the arguments for and against ratifying the U.S. Constitution. Excellent. So number 46, this one's going to be shorter, so I hope you're appreciative of that, given the last two have been quite lengthy, but very, very good information nonetheless. Let's get on to number 46. It's titled, Where Then Is the Restraint? I guarantee you this is going to be another great one. This essay by, quote, an old Whig, many of them use aliases and pseudonyms because there was a legitimate looming threat from the centralists that said, hey, you're going to comply with the U.S. Constitution or you're going to die. You're going to be persecuted. See Anti-Federalist Papers numbers 18 through 20, 49, 50, and 70. They're referencing that an old Whig wrote those papers. Appeared in the Maryland Gazette and Baltimore Advertiser on November 2nd, 1788. He says this. Let us look to the first article of the proposed new Constitution, which treats of the legislative powers of Congress, and to the 8th section, which pretends to define those powers. Interesting phraseology. We find here that the Congress, in its legislative capacity, shall have the power to lay and collect taxes, duties, and excises, to borrow money, to regulate commerce, to fix the rule for naturalization and the laws of bankruptcy, to coin money, to punish counterfeiters, to establish post offices and post roads. Notice it doesn't say maintain, it says establish. That means not a perpetual subsidization, but a singular investment. To secure copyrights to authors, to constitute tribunals, to define and punish piracies, to declare war, to raise and support armies, to provide and support a navy, to call forth the militia, to organize, arm, and discipline the militia. So for those of you who still advocate for the U.S. Constitution, the U.S. Congress is supposed to be providing for your training, your arming, and disciplining in militial arts. Because who is the militia? According to the father of the U.S. Constitution, it is you, the citizens of the states. To exercise absolute power over a district 10 miles square, independent of all the state legislatures, and to be alike absolute over all forts, magazines, arsenals, dockyards, and other needful buildings thereunto belonging. This is a short abstract of the powers given to Congress. These powers are very extensive, but I shall not stay at present to inquire whether these express powers were necessary to be given to Congress, whether they are too great or too small. My object is to consider that undefined, unbound, and unbounded, and immense power which is comprised in the following clause, quote, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or in any department or offices thereof. But we're comforted by the Federalists. They say, no, the Supremacy Clause, or not the Supremacy Clause, the Necessary and Proper Clause only extends to powers granted by the U.S. Constitution. It's not a carte blanche permission slip to the U.S. Congress to do whatever they need to provide for the general welfare of the United States, of the Union, of the states. We can be comforted by their assurances. Well, their assurances aren't so revered in the modern context, which have proven these warnings from the Anti-Federalists in 1787 to be very true. Under such a clause as this, can anything be said to be reserved and kept back from the Congress? Can it be said that the Congress have no power but what is expressed? Quote, to make all laws which shall be necessary and proper, or, in other words, to make all such laws which the Congress shall think necessary and proper, for who shall judge for the legislature what is necessary and proper? Bingo. Spot on. Perfect rebuttal to the necessary and proper clause. That right there needs to be brought and slapped right in the faces of every single justice that has ever sat on the U.S. Supreme Court. That is the limit of the necessary and proper clause. That is the issue. That is the problem. No, it is not a carte blanche paper slip to the executive, to the legislative, or to the judiciary to do whatever they think necessary and proper to provide for the general welfare of the United States. Even the father of the U.S. Constitution said, nope, that is a bastardization of what that clause is for. Justices, every single justice who has sat on the U.S. Supreme Court, even those who recognize that actual legitimate explanation, need to read that time and time and time and time again, every time the necessary and proper clause is ever hearkened to by the legislative or any litigant bringing it before their bench. Who shall set themselves above the sovereign? What inferior legislature shall set itself above the supreme legislature? To me, it appears that no other power on earth can dictate to them or control them unless by force, and force, either internal or external, is one of those calamities which every good man would wish his country at all times to be delivered from. But again, remember what Madison said. I can't remember exactly which Federalist paper he said it in, but he said, whenever the federal government goes awry, whenever it becomes tyrannical, the state legislatures are to be the first blockade to any encroachments by the federal government. If that doesn't work, the citizens of the states are duty-bound, obligated to physically remove the individuals or the government that is propagating the encroachments. That is the father of the U.S. Constitution's words, not mine. So if you're going to call me a traitor, treasonous, seditious, if you're going to label the Calhoun School of Law treasonous, traitor, insurrectionist, seditious, so on and so forth, you have to be willing to do the very same thing for the person who was at the very pivotal center of having the U.S. Constitution ever even considered by the states. Are you willing to go to that extent? This generation in America have seen enough of war and its usual, this is a great word, concomitants to prevent all of us from wishing to see any more of it, all except those who make a trade of war. But to the question, without force, what can restrain the Congress from making such laws as they please? What limits are there to their authority? I fear none at all. Oh, well, Caleb, the Articles of the Confederation didn't do that. It said expressly that the Union government couldn't do certain things. And to make sure that Union government didn't disregard that rule, there was no avenue, there was no route, there was no establishment or institutionalizing any sort of revenue which would allow the Union government, the Confederated government, to disregard the rules anyways. That's why the Articles were far more effective than the U.S. Constitution, because the U.S. Constitution says, oh, well, yeah, we have all of these legally ambiguous clauses, but we're going to trust that the best of the best men will be elected, and that legal ambiguity will not be exploited. And then they use all these taxes, they use all this revenue, they build up a force, they build up an army, multiple armies, and compel compliance. The Articles, if the elected president of the Congress tried to do that, would be laughed out, because they'd say, okay, with what money? With what guns? With what army are you going to impose these? That is the crucial difference between the Articles and the Constitution. What made the Articles effective and what makes the Constitution disineffective, ineffective, dysfunctional, and ineffective. Well, Caleb, if the Articles were true and they were effective, then the U.S. Constitution wouldn't come about. Sure. But now you're playing upon the discipline of men to impose, or to rather maintain, their government, which they did. 39 of the 70 delegates voted to ratify the U.S. Constitution. That's nowhere near unanimous, which is required by the Articles of the Confederation. The U.S. Constitution is not a legitimate government. Never has been, and is to this day not a legitimate government. So did the Articles really fall, or is it mass delusion? Take your pick. I fear none at all. For surely it cannot be justly said that they have no power but what is expressly given to them, when by the very terms of their creation they are vested with the powers of making laws in all cases necessary and proper, when from the nature of their power they must necessarily be the judges what laws are necessary and proper. Remember two very, very important quotes. Thomas Jefferson said, if you expect to be ignorant and free, you expect what never was and never will be. Knowing that the U.S. Constitution was never ratified, knowing that these different assertions from even the people authoring the U.S. Constitution, will you continue to comply with an unrepresentative, unconsented to government? Or will you choose to obey the mass delusion? Because it was never ratified. It was never consented to. It has never been pursuant to the just powers of government implemented. Remember what Benjamin Franklin said: a republic if you can keep it. It depends on you. It depends on the citizens. So with this information, you can look to an even earlier quote, Epictetus, only the educated are free. Now that you're educated, now that you're learned on this subject, will you continue to go along with the mass delusion, or will you do what James Madison and Thomas Jefferson did in 1798 and say, nope, we're not going to play along with this game. We're not going to go along with the en masse delusional tyranny. We're going to assert our right to sovereignty. We're going to fear God, who endows us with our rights, more than we're going to fear this government who believes they dictate our rights. What will you do? Back to the Anti-Federalist paper. I'm sorry, I should have kept this lecture as short as I could, but it's just so difficult not to interject. The British Act of Parliament, declaring the power of Parliament to make laws to bind America in all cases whatsoever, was not more extensive. For it is as true as a maxim that even the British Parliament neither could nor would pass any law in any case in which they did not either deem it necessary and proper to make such a law, or pretend to deem it so. And in such cases, it is not of a fathering consequence whether they really are of opinion that the law is necessary and proper, or only pretend to think so, for who can overrule their pretensions? No one. Unless we had a Bill of Rights to which we might appeal, and under which we might contend against any assumption of undue power, and appeal to the judicial branch of the government to protect us by their judgments. Do you hear that, SCOTUS? Your job isn't to give a carte blanche permission slip to the legislative. It is in fact to say, legislative, no, you do not have authority, implied or explicit. You, the SCOTUS, are to always be on the side in preference of the citizens. You have failed that time and time and time, infinite times. Again and again. That is your duty. You have violated your duty. And Thomas Jefferson prescribes exactly what happens to governments who violate or disregard their duty. This reasoning, I fear, is but too just. And yet, if any man should doubt the truth of it, let me ask him one other question. What is the meaning of the latter part of the clause which vests the Congress with the authority of making all laws which shall be necessary and proper for carrying into execution all of the powers, besides the foregoing powers vested, etc., etc.? Was it thought that the foregoing powers might perhaps admit of some restraint in their construction as to what was necessary and proper to carry them into execution? Or was it deemed right to add still further that they should not be restrained to the powers already named? Besides the powers already mentioned, other powers may be assumed hereafter as contained by implication in this Constitution. Bingo. That's the exact argument used by modern jurists, by modern lawyers, judges, and justices. Assumed powers, implied powers, a living constitution that is eternally changing even without the consent of the governed. That, specifically, necessary and proper clause, is an infinitely condemning clause in the U.S. Constitution. That singular clause should automatically dispel the Constitution from ever being a legitimate governing document, ever, from even being considered. Oh, but the Federalists said there's no need to worry because necessary and proper is still subsequent to Article 6, is preempted by Article 6. Everything necessary and proper has to also be within the framework of the U.S. Constitution. Well, that has never been obeyed. Never. Since the first day the U.S. Constitution was imposed, it has never been understood to be that way. The Congress shall judge of what is necessary and proper in all these cases and in all other cases, in short, in all cases whatsoever. Exactly. Where then is the restraint? How are Congress bound down to the powers expressly given? What is reserved or can be reserved? Yet, even this is not all. As if it were determined that no doubt should remain, by the 6th article of the Constitution, it is declared that, quote, this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutions or laws of any state to the contrary, notwithstanding. The Congress are therefore vested with the supreme legislative power without control. Exactly. Highlight that. Because it's not true. It's not true. According to the Federalists, the Congress isn't vested with infinite powers. Necessary and proper is preempted by Article 6. Or not preempted, excuse me, is qualified by Article 6. Everything necessary and proper also has to be constitutional. Well, that has never been obeyed. This warning, absolutely true, shown to be in full fruition. And the negligence of the Federalists has proven to be completely incorrect, fallen on beyond deaf ears. In giving such immense, such unlimited powers, was there In giving such immense, such unlimited powers, was there no necessity of a Bill of Rights to secure to the people their liberties? Is it not evident that we are left wholly dependent on the wisdom and virtue of the men who shall from time to time be the members of Congress? If only men were angels. That will be the repeated time and time again phrase in the Anti-Federalist Papers. If only men were angels. If only every time we elected an individual to Congress, to the executive, if only every justice who ever sat on the bench was a man of the highest wisdom and virtue, not just of our time, but of all time. If only they were angels. Does the U.S. Constitution work? And we know for a fact there has only ever been one perfect man to roam the earth. That means the U.S. Constitution, given its dependence on electing the most wise and the most virtuous of all time men, exactly why the U.S. Constitution fails. And who shall be able to say 7 years hence the members of Congress will be wise and good men, or of the contrary character? Exactly. An old Whig. Thank you for that. So if you have any questions about what was said in number 46, maybe questions about what was said in the preceding papers, or if there's a topic you'd like me to cover in a future lecture, go ahead and post them down in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to combat any lawfare waged on you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope y'all have a wonderful day. I'm not sure what the topic for the next lecture is going to be, but I'll do my best to make it as informative and entertaining as this one, if not more so. Regardless of the topic of the next lecture, until I see y'all then, I bid you all farewell.